All right, we have the guidelines to read before we listen to the case today, so if everybody will bear with me. This is a public hearing, and we are the Zoning Board of Adjustments for Putnam County, Florida. We operate under the authority of Articles 11 and 12 of the Land Development Code as amended. The primary responsibility of the board is to hear and decide appeals challenging final determinations made by the Planning and Development Services Department under the Land Development Code, and to hear and act upon requests for variances, special use permits, non-conforming use determinations, and preliminary development plans under the Land Development Code. Today we have a special use permit, so I am going to skip the section on a variance. A special use permit is special permission fashion which the zoning classification of the property does not automatically permit. If we grant a special use permit, we may impose reasonable conditions on the use of the property which must be satisfied if the special use permit is to remain valid. Unlike a change in the zoning classification, as a general rule, a special use permit applies only to the specific use requested in the application for a special use permit. The standards we use in determining whether or not to grant a special use permit are listed in Section 12.12.03 of the Land Development Code. Procedurally, we will call each case by name and number. A member of the staff will then briefly explain to us the nature of each request. We will then take any comments from the applicant or their representative, followed by any public comments concerning the request. Please direct all comments and statements to the board and not to other people in the audience. Before speaking, we will ask each person to be recognized, come forward to the lectern, and identify his or herself by name and address. After all persons wishing to speak have been heard, we will entertain a motion from the board. This motion will be voted on by the board members and become our final order. Any decision made by this board can be appealed to the circuit court. However, any appeal must be filed within 30 days after the Board of Adjustment has rendered the final order which is being appealed. All applicants have the right to withdraw their request at any time during the application process. The following cases were advertised as being considered as today's meeting, but okay, I think you guys, I got a statement in here, so that's not necessary to today's case. Are there any questions from what I just read? Okay, before the first case is heard, all people wishing to speak should need to be sworn in, so will the notary please administer the oath? Okay, the first case today is Special Use Permit 20-001. Is staff ready?
Wendy Hickey, Planning Department, Putnam County. This application is for an on-premises consumption in the C2 Commercial Retail District. The applicant is Barry Dufik, owner, John Key Esquire as agent. The location is 1023 State Road 20, Interlochen. The future land use is urban reserve, and the zoning district is commercial retail C2. It is one parcel totaling 0.76 acres. It was recently rezoned from professional office to C2. It contains a two-story commercial structure built as a residence in 1864. It has previously been used as a real estate office. Proposed use is for a wine shop with on-site consumption. No known jurisdictional wetlands are on the property, and it's not within a flood hazard area. That is the location, the future land use, and the zoning. The special use permit criteria. Per section, I'm going to quote a section of our code, which is now published on MuniCode. It has changed all our citations for our code. So you'll hear me, in this case, I'm going to say per section 45.1083 is synonymous with section 12.12.03 of the Land Development Code. So we're right now in transition. We're trying to use the new citations in place of our original code citations. The Zoning Board of Adjustments is to evaluate the application and make the determination based on the following findings of fact: that the use is consistent with the comprehensive plan and meets all the concurrency requirements. This parcel has a primary use of commercial retail and is compatible with the existing future land use designation. The use is allowed as a special use in the zoning district in which the property is located and will conform to all applicable regulations of this code and the zoning district in which it's proposed. Section 45-164 of the LDC, formerly 3.02.04, specifically identifies any vendor, establishment, or facility whose principal activity is the sale of alcoholic beverage for consumption on premises shall be permitted within the C2 district by special use permit. The location is in compliance with the separation requirements from educational facilities, religious facilities, and adult entertainment locations. The special use will not adversely impact nor unduly restrict the enjoyment of permitted uses in the surrounding area. The surrounding land uses consist of commercial and residential. The closest occupied residential parcel is 110 feet to the south. This is inclusive of a 49-foot paper right-of-way. The property to the west is vacant, and the parcel to the east contains significant wetlands. No adverse impacts or undue restrictions are foreseen based on the proposed use. The special use will not substantially diminish or impair the property values in the area or impede orderly development and improvement of the surrounding property from permitted uses. The subject parcel is located on a principal arterial. There is existing commercial development along State Road 20. No substantial or diminished property values are anticipated to impede orderly development in the area. Adequate access roads, on-site parking, on-site loading, unloading, berths, drainage have been or will be provided where required. The site will go through the development review process to ensure compliance with the Land Development Code prior to the commercial operation opening to the public. Next is adequate measures have been taken to provide egress to the property that are designed in a manner to minimize traffic impacts on local roads. Ingress and egress, though previously established, will be reviewed by FDOT at the time of the development review based on the proposed use. Adequate screening and buffering of the parcel use will be provided if needed. The property contains natural vegetative buffer along the west and the rear property lines, which are adjacent to the residentially zoned parcels, and will be reviewed for consistency with the LDC at the time of the development review. The special use will not have signs or exterior lighting that will cause glare, adversely impact the area, traffic safety, or have a negative effect on the area. Signage and lighting will be reviewed for compliance at the time of development review. There will be no undue risks to person or property from hazardous substances. Hazardous substances have not been proposed, nor shall they be allowed as part of this special use. The proposed special use will not adversely affect the general public health, safety, welfare, or the residents of Putnam County. Staff does not believe the issuance of this supplemental use will have an adverse effect on the general public health, safety, and welfare of the residents of Putnam County. The applicant has requested a special use permit to allow consumption on premises in the commercial retail C2 zoning district. Upon approval of this special use permit, the applicant will be required to go through the development review process and meet all requirements set forth in the Land Development Code and any conditions that may be added by this board. The site meets the criteria for a special use permit, and staff recommends approval. This is a couple of photos of the location so that you can see that it has area that had previously been a parking area, and it will come into compliance if there's any additional needed, and it has the area to do so. And if you have any questions?
I would just like to make one comment. In your report, it says it was built in 1864. Shouldn't that be 1964?
No, 1864.
1864?
Correct.
That place?
That place?
according to the property appraiser's records, it says 1864.
Wow, okay. Okay, all right, thank you.
Ought to be a historic building.
I started to say, yeah, it should be under the historic registry. Okay, any other questions from staff? Okay, all right, before we proceed, let's do a site visit roll call, please.
Earl Ballantine,
Yes.
Mark Fisher,
Yes.
Ed Killebrew,
No.
Linda Osborne,
Yes.
Mary Ratliff,
Yes.
TJ Smith,
Yes.
and Josie Bull, Ron West.
Yes.
Anytime I've been by there, I can see this,
I'm sorry? Oh, you've been there, that's true. Okay, we have agent for the applicant today, as Mr. John Key Esquire. Would you like to come forward and address the board? Please state your name and address for the record.
Thank you, Board. John Key, 415 St. John's Avenue, beautiful downtown Palatka. I would like to concur with the staff recommendation, of course. I think this will be a good addition to the area. The special use permit, of course, is required, and that's what we're doing here, and then the Development Review Committee. But this will be a net positive for the area and for the county. And I've known Mr. Holmes and Mr. Dufek for many years, great people, good citizens. This is going to be I hate to overuse the word destination point, but it will be a nice place for people to come and gather and relaxing and have a glass of wine. I believe they manufacture their wines as well as going to be selling them for consumption on the premises at this place. It's going to be nice, and I invite all the members of the board to stop by if they're in that area once they're opened up. If we have any questions from anyone,
Any
we'll
questions
certainly
from
be
Mr.
glad to
King?
answer them.
I've got one question. In here, it keeps saying on-site consumption. Are you going to be able to buy a bottle of wine to take home with you for a special dinner or something like that, or?
I believe that is allowed, yes. It is allowed under the ABT's guidelines as well.
It
For
is?
the office, or excuse me, for the license they'll have to obtain for that, yes.
All right, thanks.
Okay.
I have one question. What's the
Certainly.
capacity? Do you have any idea?
Capacity? How many people can be there?
Probably 25 to 30.
25 to 30 is my understanding,
Okay, thank you.
certainly. Very intimate.
Is it a local winery?
Yes, it's Bacchus Wines. Mr. Holmes here is the owner, along with his wife, Marianne, and he's been producing wines for a number of years now, and I can attest they're fine quality. They are very fine quality, very tasty, very, very nice. It's just nice. I just hate to overuse that word, but it's just nice, and it's nice to have something nice.
Okay, any other questions for Mr. Key? Okay, thank you, sir.
All right. Mr. Holmes would like,
I'll call him. All right, is there anyone else in the audience like to come forward and speak in favor of this application?
I'm really hard of hearing.
Okay, come to the mic, please. Please state your name and address for the record.
My name is John Holmes. I live at 220 Ida Boulevard in Interlaken. And basically, I just wanted to say that the building, it belongs to Mr. Dufek, and he's bought the building and doing renovations and stuff like that. It's my wife and myself who are going to actually run the business and stuff. We feel very fortunate to have got this building. It has a history, and built in 1864. 10 years ago, 12 years ago, it was totally renovated. They just took everything out except the shell and redid everything, so it's all nice and new inside. And now we're doing minor renovations and turning it into a really nice wine bar. And it's small, and we don't expect, a lot of traffic and stuff like that. It's just going to be a low-key neighborhood bar where, people can get together and really have a nice time. And that's what we do.
Okay, Any questions for Mr. Holmes? Okay, thank you, sir. Anyone else wishing to come forward and speak in favor of this application? Okay, I'll ask the question, anyone wanting to come forward and speak in opposition, but there's no one else coming forward. Okay, thank you very much. And at this time, we will close it to the public and open it up for board discussion and motion.
Madam Chairman, I move we approve special use permit 21-001 as the request meets the criteria for special use permit as required by section 12-1203 of the Putnam County Land Development Code, and authorize the chairman to sign the final order.
Second it.
All right, we have a motion second to approve special use permit 21-007. Is there any further discussion? If not, all of those in favor, please indicate by raising your right hand. 1, 2, 3, 4, 5, 6, 7. All right, motion carries 7-0. So just to remind you, there is a 30-day appeal process, but good luck in your endeavor. Thank you very much. Okay, thank you. Okay, the next thing on the agenda, can we, well, let's do the minutes, and then Mr. Perry has a presentation to give to us. So we need to approve the minutes for March 17, 2021. Has everybody had a chance to review the minutes?
Move they be approved as read.
Second.
We have a motion second to approve the March 17, 2021 minutes. All in favor, say aye.
Aye.
All opposed, same sign. Motion carries 7-0. Okay. All right, Mr. Perry, it is, you are up for us today. Thank you.
Well, thank you very much, Madam Chair, and good afternoon, Zoning Commission members. What I have to share with you is not directed to any particular person or in response to a particular incident involving this board. It is simply for informational purposes only. Mr. Jim Torano, the Executive Director of Planning and Development Services, has asked that I provide a brief presentation on 3 subjects which impact your ability to be effective board members who are capable of performing their duties in accordance with the law. This is the same presentation that I made to the Planning Commission earlier this week, or last week, I should say. First thing I'd like to talk to you about is the Sunshine Law. Please note that this is an actual law. In 1967, the Florida legislature enacted the Government in the Sunshine Law. This law can be found in Chapter 286 of the Florida statutes. This statute establishes a basic right of access of citizens to most meetings of boards, commissions, and other governing bodies of state and local governmental agencies or authorities. The Putnam County Zoning Commission, having been formed pursuant to the authority of the Putnam County Commission, is subject to the Government in the Sunshine Law, as is, of course, the Board of County Commissioners. The practical effect of this law on this board is simple. All our meetings must be properly noticed, open to the public, and any records generated by the board are public records, and they can be requested and inspected by the public. The Public Records Law was codified at Florida Statutes 119.01 in 1991. Now, there are exemptions to the Sunshine Law and the Public Records Law, but quite frankly, I can't think of any exemptions that would apply to this board. As members of this board, what you must remember is that you cannot meet outside of a properly noticed and scheduled meeting. You must not discuss a matter pending before the board or that you know is to be brought before the board unless that discussion is taking place at a properly noticed and scheduled meeting. If this board attempts to take any official action outside of a properly noticed and scheduled meeting, it will not be binding on anyone. The second issue I'd like to mention involves ex parte communications. An ex parte communication is an oral or written communication which is made without proper notice to all parties and or without the participation of all parties to an administrative proceeding such as this meeting and is not on the public record. An ex parte communication is, in the most serious instance, an attempt to sway or influence a decision of this board. Some ex parte communications may be designed or intended to solicit some indication as to how a board member views a particular matter and be inclined to vote on that matter. The ex parte rule is designed to preserve the due process rights of all parties to an administrative hearing. I caution you to avoid contacting or receiving a communication from anyone who has a case or an interest in any matter before this board. If you are contacted, immediately inform that person that you cannot speak to them. Even the most innocent conversation could result in your disqualification from discussing a matter with your fellow board members and/or voting on a matter. You must make sure to maintain your impartiality at all times. Every board member must avoid even the appearance of impropriety. So that we are clear, there can be no verbal or written communication with any interested party outside this meeting. Now, before anybody asks, this includes sign language, Morse code, smoke signals, any other thing that comes to your mind. Just don't do it. Number 3, and closely aligned with ex parte communications, and they often overlap, is conflict of interest in issues. In the context of your service on this board, a conflict of interest occurs when an individual's personal interest, whether family, friendship, financial, or social factors, could compromise his or her judgment, decisions, or actions as a board member. Being human, we often seek to help or be nice to someone. This is not the place for those sentiments. It is, however, for this board to work together to fashion remedies that may help reach an equitable resolution. Not properly recognizing and dealing with a conflict of interest will undermine the integrity of this board. You must be willing to ask yourself the following. Number 1, does your knowledge of the facts and circumstances surrounding a particular matter render you unable to consider that matter in a fair and impartial manner? Your knowledge about a particular matter must not be obtained through an ex parte communication. Number 2, does your relationship with an applicant render you unable to consider a particular matter in a fair and impartial manner? Would an applicant expect special treatment from you? If so, recuse yourself. Number 3, am I making a decision that benefits an applicant that is not justified? For instance, a conflict of interest would arise if you owned a piece of property adjacent to an applicant and your decision benefited your property in some way. As I'm sure you now realize, the Sunshine Law, the rule against ex parte communication, and conflicts of interest are in many respects intertwined. Your effectiveness as a board member will be defined by your ability to adhere to these relatively simple rules of impartiality. If you're ever about to take an action which you feel might violate the Sunshine Law, cause you to receive an ex parte communication, or you think presents a conflict of interest, please call me before doing anything. I'll make sure that you can have my cell phone number, email address, or whatever. So if you do have a question about any of those 3 subjects, please let me know before you take any action. Thank you very much. That's all I have. I'll answer any questions if you have any.
Okay, I have a question, just the Robert's Rules of Order cheat sheet that you just passed out.
Yes,
I don't know how in-depth you want to go, but it says, oh, this is adjourn, okay, just a majority vote, so you can say aye to, yay, we're gonna adjourn, is that, that's all you have to do? You don't have to take a hand count vote? It's just a majority?
Yeah, that'll be fine,
Okay.
Madam Chair. Yeah.
But I was also reading something on my own time that was talking about mentioning in the minutes a motion and not having to mention who seconded the motion. Are you familiar with that?
Not really.
Okay.
But it certainly doesn't hurt to put it in there, the more documentation that you have, so we can trace back if we need to.
Well, that's true, but then it said that in the Robert's Rules of Order that I was reading, that you indicate the person who made the motion, but you did not have to indicate the person who made the second. So I was just curious. Okay,
It's your preference, ma'am.
okay, all right.
It really is. That's, as
Right.
long as, we have had, quite frankly, we had an instance the other day where we were back looking at a video of a meeting, trying to find out who did second things. So, it
Interesting.
might be it might be wise to go ahead and just make sure that, just for the record purpose. If it's in conflict with Robert's rules, then of course I would go with whatever Robert's rule says. But like I said, it's funny that you mentioned that, Madam Chair, because we just had an instance where we were actually trying to find out who did second a motion.
Okay.
And, but I don't think you can go wrong either way.
Well, I know Robert's Rules of Order can get a little complicated, so.
Well, it does. It's quite complicated. As a
Quite
matter of fact, there's a book, I mean, Mr. Smith used to have, I guess Mr. Reynolds uses now. And you ever want to try and go to sleep at night, pick that
Read
up.
that.
It's not the most stimulating reading, but for the purposes of this board, I must say that both the planning board and the zoning board, since I've been working with both boards, I think that, quite frankly, we do things really good. A lot better than what I've seen in other locations, and quite frankly, I have done similar duty in other counties, and sometimes it is so confusing that, quite frankly, you don't know what's going on. But the other thing I'd like to mention, if you don't mind, Madam Chair, is that one of the things Mr. Troiano also mentioned is that we're trying, and I think the planning board has pretty much picked this up, and this is for you and the members to consider, is before every case that comes up, that there be a question asked of the board, has there been any ex parte communications?
Well, usually, I mean, I think the honesty of the board, they usually will admit to the ex parte,
And I don't
communication.
doubt that for a moment, ma'am. I'm just relaying a message.
Yeah, I understand that, but I'm just
I don't
saying-
doubt that for a moment, but I just thought I'd mention it because I was asked to mention it.
Yeah, okay.
But of course, it's up to you, Madam Chair, and the members of this honorable committee, and so we'll go for that.
I mean, I know on several occasions, board members have said that they haven't spoken to the
Yes, ma'am, and I've seen that, and I'll tell you right now, that's the way to do it, but that's what I'm talking about, is that we have committees and commissions here in Putnam County that I really think really do adhere to the rules, and that's really refreshing in a lot of ways. But
There are times when owners will come out and meet you on the property and want to talk about it.
Yeah.
Yeah, just walk away.
you know, that's kind of, I've had people, Mary, come up to me and say, well, what about that? Somebody just wants to talk to me. Well, if they want to talk to you, they can talk to you from right there. And I mean, and you'll think, well, God, that sure is problematic. They have to come all the way down here. All our members deserve to have the same information, not to be relayed through somebody or you have information that they don't have. So if it means enough to them, they'll come down and address the board. But I thank you for your time, and I know that
Thank you.
everybody has other things to do. Thank you very much, Madam Chair.
Anybody have any questions for Mr. Perry? All right, thank you, sir. Okay, we need a motion to adjourn.
Make a motion to adjourn.
All right. All in favor of adjournment? Say aye.
Aye.
All right, we stand adjourned.
We done.